Legislative hearings. A. Increase in aid of legislation. B. Oversight functions. There are two provisions on legislative hearing, sections 21 and 22. Section 21 is about legislative investigations in aid of legislation. Who may appear? Any person. Who may be summoned? Anyone except the President and Supreme Court members, Senate, Ermita. Was the subject matter? Any matters for purpose of legislation. Obligatory force of appearance mandatory. Section 22 Oversight function. Who may appear? Department heads and others. Who may be summoned? Each house may only request the appearance of department heads. Subject matter. Matters related to the department only. Obligatory force of appearance discretionary. Section 21. The Senate or the House of Representatives or any of its respective committees may conduct inquiries in aid of legislation in accordance with its duly published rules of procedure. The rights of persons appearing in or affected by such inquiries shall be respected. Power of inquiry. Who has the power? The Senate of the House or the House of Representatives or any of its respective committees may conduct inquiries in aid of legislation. Nature. The power of inquiry is an essential and appropriate auxiliary to the legislative action. Arnold versus Nazareno. It has been remarked that the power of legislative investigation may be implied from the express power of legislation and does not itself have to be expressly granted. Limitations. Number 1, it must be in aid of legislation. Number 2, it must be in accordance with its duly published rules of procedure. Number 3, the rights of persons appearing in or affected by such inquiries shall be respected. Number 4, power of Congress to commit a witness for contempt terminates when the legislative body ceases to exist upon its final adjournment. Reasons for the limitations. The reason is in the past, this power was much abused by some legislators who use it for illegitimate ends to browbeat or intimidate witnesses, usually for grandstanding purposes only. There were also times when the subject of inquiry was purely private in nature and therefore outside the scope of the powers of Congress. Scope of questions. It is not necessary that every question propounded to a witness must be material to a proposed legislation. Arnold versus Nazareno. This is because the legislative action is determined by the information gathered as a whole. Who may be summoned under Section 21? Senate versus Ermita specified who may and who may not be summoned to Section 21 hearing. Thus, under this rule, even a department head who is an alter ego of the President may be summoned. Thus, too, the chairman and members of the Presidential Commission on Good Government, PCGG, are not exempt from summons in spite of the exemption given to them by President Cory Aquino during her executive rule. The court ruled that anyone except the President and Justice of the Supreme Court may be summoned. Power to punish. Legislative contempt. The power of investigation necessarily includes the power to punish a contumacious witness for contempt. Acts punished as legislative contempt. The U.S. Supreme Court, in the case of Marshall v. Gordon, mentions 1. Physical obstruction of the legislative body and the discharge of its duties. 2. Physical assault upon its members for action taken or words spoken in the body. 3. Obstruction of its officers in the performance of their official duties. 4. Prevention of members from attending so that their duties might be performed. 5. Contumacy and refusing to obey orders, to produce documents or give testimony, which was the right to compel. Power to punish, contempt, and local legislative bodies. The power to punish may not be claimed by local legislative bodies. Negros Oriental Electrical Company versus Sangguniang Panlungsod. Power to punish is sui generis. The exercise of the legislature of contempt power is a matter of preservation and independent of the judicial branch. Such power is sui generis. Question. When may a witness in an investigation be punished for contempt? Answer. When a contumacious witness testimony is required in a matter into which the legislature or any of its committees has jurisdiction, in short, the investigation must be in aid of legislation. Arnold Nazareno. Question: for how long may a private individual be imprisoned for the legislature for contempt? For HR, until final adjournment of the body. For Senate, offender could be imprisoned indefinitely by the body provided that punishment did not become so long as to violate due process. Rights of person. Philcomstat has no reasonable expectation of privacy over matters involving their offices in a corporation where the government has interest. Sabio versus Gordon. Court and the committee. A court cannot enjoin the appearance of a witness in a legislative investigation. Bernas, the general rule of fairness, which is what due process is about, could justify exclusion of persons from appearance before the committee. Q. Section 1 of EO 464 provides that all heads of department of the executive branch shall secure the consent of the President prior to appearing before House of Congress. Does this contravene the power of inquiry vested in the Congress? Is Section 1 valid? Answer: valid. The Supreme Court read Section 1 of EO 464 to mean that department heads need the consent of the President only in question hour, contemplated in Section 22 of Article 6. The reading is dictated by the basic rule of construction that issuance must be interpreted as much as possible in a way that will render it constitutional. Section 1 of EO 464 cannot be applied to appearances of department heads in inquiries in aid of legislation. Congress is not bound in such instances to respect the refusal of the department head in such inquiry, unless a valid claim of privilege is subsequently made, either by the President or by the Executive Secretary. Senate versus Ermita. Power of inquiry versus executive privilege. Senate versus Ermita. Congress has undoubtedly has a right to information from the executive branch whenever it is sought in aid of legislation. If the executive branch withholds such information on the ground that it is privileged, it must so assert it and state the reason therefore and why it must be respected. Justice Carpio Morales in Senate versus Ermita. Neri versus Senate. Was the claim of executive privilege properly invoked in this case? Yes, according to Justice Leonardo de Castos Ponentia. For the claim to be properly invoked, there must be a formal claim by the President stating the precise and certain reason for preserving confidentiality. The grounds relied upon by Executive Secretary Ermita are specific enough, since what is required is only an allegation be made whether the information demanded involves military or diplomatic secrets, closed-door cabinet meetings, etc. The particular ground must only be specified in the following statement of grounds by Executive Secretary Ermita satisfies the requirement. The context which executive privilege is being invoked is that the information sought to be disclosed might impair our diplomatic as well as economic relation with the People's Republic of China. Neri versus Senate Committee. Background. This case is about the Senate investigation of anomalies concerning the NCTE project. During the hearings, former NEDA head Romulo Neri refused to answer certain questions involving his conversations with President Arroyo on the ground they are covered by executive privilege. When the Senate cited him in contempt and ordered his arrest, Neri filed a case against the Senate with the Supreme Court. On November 25, 2008, the Supreme Court ruled in favor of Neri and upheld the claim of executive privilege. Issues. Did the Senate committees commit grave abuse of discretion in citing Neri in contempt and ordering his arrest? Ruling. Yes, the Supreme Court said that the Senate committee committed grave abuse of discretion in citing Neri in contempt. The following were reasons given by the Supreme Court. A. There was a legitimate claim of executive privilege. B. Senate committee did not comply with the requirement laid down in Senate versus Ermita that the invitation should contain the possible needed statute which prompted the need for the inquiry, along with usual indication of the subject of inquiry and the questions relative to and in furtherance thereof. C. A reading of the transcript of the committee's proceeding reveals that only a minority of the members of the Senate Blue Ribbon Committee was present during the deliberations. Thus, there is a cloud of doubt as to the validity of contempt order. D. The Senate Rules of Procedure in aid of legislation were not duly published in accordance to Section 21 of Article 6. The contempt order is arbitrary and precipitate because the Senate did not first rule on the claim of executive privilege and instead dismissed Neri's explanation as unsatisfactory. This is despite the fact that Neri is not an unwilling witness. Hence, the Senate order citing Neri in contempt and ordering his arrest was not valid. Power of inquiry, Commander-in versus Commander-in-Chief, power of the President. Since the President is Commander-in-Chief of the Armed Forces, she can demand obedience from military officers. Military officers who disobey or ignore her command can be subjected to court-martial proceedings. Thus, for instance, the President as Commander-in-Chief may prevent a member of the Armed Forces from testifying because a legislative inquiry. A military officer who disobeys the President's directive may be made to answer before a court-martial. Since, however, Congress has the power to conduct legislative hearings, Congress may make use of remedies under the law to compel attendance. Any military official whom Congress summons to testify before it may be compelled to do so by the President. If the President is not so inclined, the President may be commanded by judicial order to compel the attendance of any of the military officer. Final judicial orders have the force of the law of the land, which the President has the duty to faithfully execute. Section 22. The heads of departments may, upon their own initiative, with the consent of the President or upon the request of either House, as the rules of each House shall provide, appear before and be heard by such House on any matter pertaining to their department. Written questions shall be submitted to the President of Senate or the Speaker of the House of Representatives at least 3 days before their scheduled appearance. Interpellations shall not be limited to written questions, but may cover matters related thereto. When the security of the state or the republic interest so requires, and the President so states in writing, the appearance shall be conducted in executive session. Purpose of Section 22. The provision formalizes the oversight function of Congress. Section 22 establishes the rule for the exercise of what is called the oversight function of Congress. Such function is intended to enable Congress to determine how laws it has passed are being implemented. Oversight function, broadly defined, congressional oversight embraces all activities undertaken by Congress to enhance its understanding of and influence over the implementation of legislation it has enacted. The acts done by Congress in the exercise of its oversight powers may be divided into 3 categories, to wit, scrutiny, investigation, and supervision. Appearance of heads of department by their own initiative. The heads of departments may, upon their own initiative, with the consent of the President, appear before and be heard by either House on any matter pertaining to their department. Why permission of the President needed? In deference to separation of powers, and because department heads are alter egos of the President, they may not appear without the permission of the President. Exemption from summons applies only to department heads. It should be noted that the exemption from summons applies only to department heads and not to everyone who has cabinet rank. Does Section 22 provide for a question hour? Answer: Burness Primer. No. The question hour is proper to parliamentary system where there is no separation between the legislative and executive department. Section 22, unlike in the question hour under the 1973 Constitution, has made the appearance of department heads voluntary. But wait, the Supreme Court in Senate versus Ermita, adopting the characterization of Constitutional Commissioner Hilario Davide, calls Section 22 as the provision on question hour. Section 22 pertains to the power to conduct a question hour. the objective of which is to obtain information in pursuit of Congress oversight function. Reconcile. Although the court decision calls this exercise a question hour, it does so only by analogy with its counterpart in parliamentary practice. Appearance at the request of Congress. The heads of departments may, upon their own initiative, with the consent of the President, or upon the request of either House, as the rules of each House shall provide, appear before and be heard by such House on any matter pertaining to their department. Written questions. Written questions shall be submitted to the Senate President or the House Speaker at least 3 days before their scheduled appearance. Scope of interpellations. Interpellations shall not be limited to written questions, but may cover matters related thereto. Executive session. The appearance shall be conducted in executive sessions when the public interest so requires and the President so states in writing. Congress may refuse the initiative. Because of separation of powers, department secretaries may not impose their appearance upon either house. Hence, the Congress may refuse the initiative taken by the department secretary. Emergency powers. Declaration of the existence of a state war. Delegation of emergency powers. War power. Power to declare existence of state of war. Rewarding of the provision. Section 23. Congress, by a vote of two-thirds of both houses in joint session assembled, voting separately, shall have the sole power to declare the existence of a state war. Power to declare existence of a state war. The Congress, by a vote of two-thirds of both houses in joint session assembled, voting separately, shall have the sole power to declare the existence of a state war. Rewarding of the provision. From 1935 Constitution's power to declare war to power to declare the existence of state war under 1987, the difference between the two phraseologies is not substantial, but merely in emphasis. The two phrases were interchangeable, but the second phrase emphasizes more the fact that the Philippines, according to Article 2, Section 2, renounces aggressive war as an instrument of national policy. Question. May a country engage in war in the absence of declaration of war? Yes. The actual power to make war is lodged in the executive. The executive, when necessary, may make war even in the absence of a declaration of war. Delegation of emergency powers. Requisites for delegation, duration of delegation, powers that may be delegated, withdrawal of powers. Section 23. In times of war, that's number 2. In times of war or other national emergency, the Congress may, by law, authorize the President, for a limited period and subject to such restrictions as it may prescribe, to exercise powers necessary and proper to carry out the declared national policy, unless sooner withdrawn by resolution of the Congress. Such powers shall cease upon the next adjournment thereof. Requisites for the delegation 1997 bar question. There must be a war or other national emergency. Number 2. Law authorizing the President for a limited period and subject to such restrictions as Congress may prescribe. Number 3. Power to be exercised must be necessary and proper to carry out the declared national policy. Duration of the delegation. Until withdrawn by resolution of Congress. Until the next adjournment of Congress. Powers that may be delegated. Congress may authorize the President to exercise powers necessary and proper to carry out a declared national policy. Note that the nature of the delegable power is not specified. It is submitted that the President may be given emergency legislative powers if Congress so desires. Withdrawal of powers. Congress may do it by a mere resolution, and such resolution does not need presidential approval. Bills, legislative process. Origination clause. Exclusive origination clause. Bills that must exclusively originate from House of the Representative. Origination from the House, meaning reason for exclusion. Exclusive origination. Senate may propose amendments. Scope of Senate's power to introduce amendment. That's Section 24. All appropriation, revenue, or tariff bills. Bills authorizing increase of the public debt. Bills of local application and private bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendments. Origin of money bills, private bills, and bills of local application. All appropriation, revenue, or tariff bills, bills authorizing increase of the public debt, Bills of local application and private bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendments. Bills that must exclusively originate from the House of the Representative. 1. Appropriation bills. 2. Revenue bills. 3. Tariff bills. 4. Bills authorizing increase of the public debt. 5. Bills of local application. 6. Private bills. Origination from the House. The exclusivity of the prerogative of the House of Representatives means simply that the House alone can initiate the passage of revenue bill, such that if the House does not initiate one, no revenue law will be passed. Tolentino versus Secretary of Finance. Reason for exclusive origination. The district representatives are closer to the pulse of the people than senators are, and are therefore in a better position to determine both the extent of the legal burden they are capable of bearing and the benefits that they need. It is more numerous in membership and therefore also more representative of the people. Senate may propose amendments. The addition of the word exclusively in the Constitution is not intended to limit the power of the Senate to propose amendments to revenue bills. Tolentino versus Secretary of Finance. Scope of the Senate's power to introduce amendments. Once the House has approved a revenue bill and passed it on to the Senate can completely overhaul it by amendment of parts or by amendment by substitution and come out with one completely different from what the House approved. Textually, it is the bill which must exclusively originate from the House, but the law itself, which is the product of the total bicameral legislative process, originates not just from the House, but from both Senate and House. Tolentino versus Secretary of Finance. One bill, one subject rule. Section 26. Every bill passed by the Congress shall embrace only one subject, shall be expressed in the title thereof. Mandatory nature of the rule. Every bill passed by the Congress shall embrace only one subject. The subject shall be expressed in the title of the bill. This rule is mandatory. The requirement is satisfied when, number 1, all parts of the law relate to the subject expressed in the title. 2. It is not necessary that the title be a complete index of the content. Phil Conservers Jimenez. Purpose of the rule: to prevent hodgepodge or long-rolling legislation, to prevent surprise or fraud upon the legislature, to fairly appraise the people. Central Capiz versus Ramirez. Liberal interpretation of the rule. The rule should be given a practical rather than a strict construction. It should be sufficient compliance with such requirement if the title expresses the general subject and all the provisions of the statute are germane to the general subject. Sumulong versus Comelec. Germane, a partial exemption from the increase of tax imposed, is not a deviation from a general subject of the law. Insular Lumber versus CTA. A tax may be germane and reasonably necessary for the accomplishment of the general object of the decree for regulation. Tio versus BRV. A repelling clause does not have to be expressly included in the title of the law. Philippine Judges Association versus Prado. The creation of a new legislative district is germane to the conversion of a municipality to an urbanized city. Tobias versus Abalos. The reorganization of the remaining administrative regions is germane to the general subject of establishing the ARMM. Chiyong Bayan versus Orbos. The expansion in the jurisdiction of the Sandigan Bayan does not have to be expressly stated in the title of the law. An act further defining the jurisdiction of the Sandigan Bayan, because such is the necessary consequence of the amendment. Lacson versus Executive Secretary. A provision that states that no election officer shall hold office for more than 4 years is relevant to the title. An act providing for a general registration of voters, adopting a system of continuing registration, prescribing procedures thereof, and authorizing the appropriation of funds thereof, as it seeks to ensure the integrity of the registration process by providing guidelines for the COMELEC to follow in the reassignment of election officers. The Guzman versus COMELEC. The abolition of 2 municipalities is but a logical consequence of its merger to create a city, not germane. Prohibition of places of amusement should be included in the title of the law, which only provides for the regulation of places of amusement, De La Cruz versus Parras. Passage of a bill. Section 26. No bill passed by either house shall become a law unless it has passed 3 readings on separate days and printed copies whereof, in its final form, have been distributed to its members 3 days before its passage, except when the President certifies to the necessity of its immediate enactment to meet a public calamity or emergency. Upon the last reading of a bill, no amendment thereto shall be allowed, and the vote thereon shall be taken immediately thereafter, and the yeas and the nays entered in the journal. Rules. 1. No bill passed by either house shall become a law unless it has passed 3 readings on separate days. 2. Printed copies of the bill in its final form should be distributed to the members 3 days before its passage, except when the President certifies to the necessity of its immediate enactment to meet a public calamity or emergency. 3. Upon the last reading of a bill, no amendment thereto shall be allowed. 4. The vote on the bill shall be taken immediately after the last reading of a bill. 5. The yeas and the nays shall be entered in the journal. Exception. The certification of the President dispenses with the reading on separate days and the printing of the bill in the final form before its final approval. Tolentino versus Secretary of Finance. Operative. All decrees which are not inconsistent with the Constitution remain operative until they are amended or repealed. Quingona versus Carrage. Procedure. A bill is introduced by any member of the House of Representatives or Senate, except for some measures that must originate only in the former chamber. 2. The first reading involves only a reading of the number and title of the measure and is referral by the Senate President or the Speaker to the proper committee for study. 3. The bill may be killed in the committee, or it may be recommended for approval with or without amendments, sometimes after public hearings are first held thereon. If there are other bills of the same nature or purpose, they may all be consolidated into one bill under common authorship or as a committee bill. 4. Once reported out, the bill shall be calendared for second reading. It is at this stage that the bill is read in its entirety, scrutinized, debated upon, and amended when desired. The second reading is the most important stage in the passage of the bill. 5. The bill, as approved in second reading, is printed in its final form and copies thereof are distributed at least 3 days before the third reading. On third reading, the members merely register their votes and explain them if they are allowed by the rules. No further debate is allowed. Once the bill passes third reading, it is sent to the other chamber, where it will also undergo the 3 readings. It is also approved by the second house. It will then be submitted to the President for his consideration. The bill is enrolled when printed as finally approved by the Congress, thereafter authenticated with the signatures of the Senate President, the Speaker, and the Secretaries of their respective chambers, and approved by the President. Reasons for 3 readings. To address the tendency of legislators on the last day of the legislative year, when legislators were eager to go home, to rush bills through and insert matters which would not otherwise stand scrutiny in leisurely debate. Question. If the version approved by the Senate is different from the approved by the House of Representatives, how are the differences reconciled? In a bicameral system, bills are independently processed by both houses of Congress. It is not unusual that the final version approved by one house differs from what has been approved by the other. The conference committee, consisting of members nominated from both houses, is an extra constitutional creation of Congress, whose function is to propose to Congress ways of reconciling conflicting provisions found in the Senate version and in the House version of a bill. Presidential approval, veto, or inaction, legislative consideration. Section 27. Every bill passed by the Congress shall, before it becomes a law, be presented to the President. If he approves the same, he shall sign it. Otherwise, he shall veto it and return the same with his objection to the House where it originated, which shall enter the objections at large in its journal, and proceed to consider it. If after such reconsideration 2/3 of the members of such House shall agree to pass the bill, it shall be sent together with the objections to the other House, by which it shall likewise be reconsidered. And if approved by 2/3 of all the members of that House, it shall become a law. In all such cases, the votes of each House shall be determined by yeas or nays, and The names of the members voting for or against shall be entered in his journal. The President shall communicate his veto of any bill to the House where it originated within 30 days after the date of receipt thereof. Otherwise, it shall become a law as if he had signed it. Three methods by which a bill may become a law. 1. The President signs it. 2. The President vetoes it, but the veto is overridden by 2/3 vote of the members of each houses. When the President does not act upon the measure within 30 days after it shall have been presented to him. Presidential approval. 1. Passed bill is presented to the President. 2. President signs the bill if he approves the same. 3. The bill becomes a law. Presidential veto. Passed bill is presented to the President. President vetoes the bill if he does not approve of it. He returns the passed bill with his objection to the House where it originated. Veto message. General rule: if the President disapproves the bill approved by Congress, he should veto the entire bill. He is not allowed to veto separate items of a bill. Exception: President may veto an item in case of appropriation, revenue, and tariff bill. Appropriation, revenue, and tariff bill. President may veto inappropriate provisions or riders. Legislative reconsideration of the bill. The House where the bill originated enters the objections of the President at large in its journal. Said House reconsiders the bill. 2/3 of the members of such House agree to pass the bill. The bill together with the objection is sent to the other House, by which it is also reconsidered. The other House approves the bill by 2/3 of all the members of that House. 6. The bill becomes a law. In all such cases, the votes of each House shall be determined by yeas or nays. The names of the members voting for or against shall be entered in his journal. Question: when does the Constitution require that the yeas and nays of the members be taken every time a House has to veto? Answer: upon the last and third reading of a bill, Article 6, Section 26, Number 2, at the request of 1/5 of the members present, Article 6, Section 16, Number 4, in repassing a bill over the veto of the President, Article 6, Section 27, Number 1. Presidential inaction: passed bill is presented to the President. President does not approve nor communicate his veto to the House where the bill originated within 30 days. The bill becomes a law. Item veto. Section 27. The President shall have the power to veto any particular item or items in an appropriation, revenue, or tariff bill, but the veto shall not affect the item or items to which he does not object. Again, the general rule is the President disapproves the bill approved by Congress. He should veto the entire bill. He is not allowed to veto separate items of a bill. Exemption: President may veto an item in cases of appropriation, revenue, and tariff bills. President may veto inappropriate provisions or riders. An item is an indivisible sum of money dedicated to a stated purpose. Item, purpose, amount in a tax measure. An item refers to the subject of the tax and the tax rate. It does not refer to the entire section imposing a particular kind of tax. The President may not veto the method or manner of using an appropriated amount. Bengson versus Drillon. Doctrine of inappropriate provision. Doctrine: a provision that is constitutionally inappropriate for an appropriation bill may be singled out by veto even if it's not an appropriation or revenue item. Gonzalez versus Macaraig. Reason for the doctrine: the intent behind the doctrine is to prevent the legislature from forcing the government to veto an entire appropriation law, whereby paralyzing government. Inappropriate provision. Repeal of laws. Repeal of laws should not be done in Appropriation Act but in separate law. Phil Consta versus Enriquez. Use this doctrine carefully. Inappropriate provision. Repeal of laws. Repeal of laws should not be done in Appropriation Act in a separate law. Phil Consta versus Enriquez. The requirement of congressional approval for the release of funds for the modernization of the AFP must be incorporated in a separate bill. Being an appropriate provision, it was properly vetoed. Phil Consta versus Enriquez. The proviso on power of augmentation from savings can by no means be considered a specific appropriation of money. Gonzalez versus Macaraig. Appropriation provision. The special provision providing that the maximum amount of the appropriation for the DPWH to be contracted for the maintenance of national roads and bridges should not exceed 30% is germane to the appropriation for road maintenance. It specifies how the item shall be spent. It cannot be vetoed separately from the item Philconsa versus Enriquez. The special provision that all purchases of medicine by the AFP should comply with Generics Act is a mere advertence to an existing law. It is directly related to the appropriation and cannot be vetoed separately from the item Philconsa versus Enriquez. Executive impoundment, refusal of the President to spend funds already allocated by Congress for a specific purpose, Philconsa versus Enriquez. Legislative veto. A congressional veto is a means whereby the legislature can block or modify administrative action taken under a statute. It is a form of legislative control in the implementation of particular executive action. Fiscal powers / power of the purse, taxation and constitutional law. Power of the purse. Congress is the guardian of the public treasury. It wields the tremendous power of the purse. The power of the purse comprehends both the power to generate money for the government by taxation and the power to spend it. Taxation, Section 28. The rule of taxation shall be uniform and equitable. The Congress shall evolve a progressive system of taxation. Taxation refers to the inherent power of the state to demand enforced contribution for public purposes. Taxation is so pervasive that it reaches even the citizen abroad and his income earned from such outside the state. General limit for a public purpose, due process and equal protection clause, Season versus Ancheta. Specific limit, uniform and equitable, Section 28, C29. Number 2. Exercise of the power primarily vested in the national legislature. Purposes: to raise revenue, instrument of national economic and social policy, tool for regulation. 4. The power to keep alive. Tax. Taxes are enforced proportional contribution from person and property levied by the law-making body of the state by virtue of its sovereignty for the support of the government and all public needs. Justice Holmes said, taxes are what we pay for civilized society. Public purpose. It is fundamental in democratic governments that taxes may be levied for public purposes, for public purpose only. Without this element, a tax violates the due process clause and is invalid. In Planters Products, PPI versus Fertifil Corp., the court had occasion to review the validity of LOI 1465, a Marshall Rule product which imposed a 10 peso capital contribution for the sale of each bag of fertilizer until adequate capital is raised to make PPI viable. PPI was private corporation, clearly therefore the imposition was for private benefit and not for public purpose. Limitation for power of taxation. Number 1. Rule of taxation shall be uniform and equitable. Congress shall evolve a progressive system of taxation. Number 2. Charitable institutions, etc., and all lands, building, and improvements actually directly and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation. All revenues and assets of non-stock, non-profit educational institutions used actually directly and exclusively for educational purposes shall be exempt from taxes and duties. Law granting tax exemption shall be passed only with the concurrence of the majority of all the members of Congress. Article 6, Section 29, Number 4. Uniform. Uniformity signifies geographical uniformity. A tax is uniform when it operates with the same force and effect in every place where the subject is found. Uniformity in taxation versus equality in taxation. Uniformity in taxation means the person or things belonging to the same class shall be taxed rate. It is distinguished from equality in taxation in that the latter requires the tax imposed to be determined on the basis of the value of the property. Tan versus Del Rosario. Uniformity means 1. The standards that are used therefore are substantial and not arbitrary. 2. The categorization is germane to achieve the legislative purpose. 3. The law applies, all things being equal, to both present and future conditions. And 4. The classification applies equally well to all those belonging to the same class. There is a difference between the homeless people and the middle class. The two social classes are differently situated in life. Tolentino versus Secretary of Finance. Equitable. The present Constitution adds that the rule of taxation shall also be equitable, which means that the tax burden must be imposed according to the taxpayer's capacity to pay. Progressive system of taxation. The Congress shall evolve a progressive system of taxation. Tax system is progressive when the rate increases and the tax base increases. Reason for progressive system. The explicit mention of progressive taxation in Constitution reflects the wish of the Commission that the legislature should use the power of taxation as an instrument for a more equitable distribution of wealth. Directive, not a judicially enforceable right. The directive to evolve a progressive system of taxation is addressed to Congress and not a judicially enforceable right. Tolentino versus Secretary of Finance. Indirect taxes. The Constitution does not prohibit the imposition of indirect taxes, which are regressive. The provision simply means that direct taxes are to be preferred and indirect taxes should be minimized as much as possible. It does not require Congress to avoid entirely indirect taxes. Otherwise, sales taxes, which are the oldest form of indirect taxes, will be prohibited. The mandate to Congress is not to prescribe, but to evolve a progressive system of taxation. Tolentino versus Secretary of Finance. Delegation of powers to tax, condition, tariff and custom code. Limitation imposed regarding the flexible tariff clause. Section 28. Number 2. The Congress may by law authorize the President to fix within specified limits and subject to such limitations and restrictions as it may impose tariff rates, import and export quotas, tonnage, wharfage dues, and other duties or imposed within the framework of the National Development Program of the government. Conditions in the delegation of the power to tax. 1. Delegation must be made by law. 2. The power granted is to fix tariff rates, import and export quotas, tonnage and wharfage dues, and other duties and imposed. 3. The said power is to be exercised within specified limits and subject to such limitations and restrictions as the Congress may impose. 4. The authorization of such power must be within the framework of the National Development Program of the government. Tariff and Custom Code. Flexible Tariff Clause. The President is given by the Tariff and Custom Code ample powers to adjust tariff rates. Flexible Tariff Clause. The President may fix tariff rates, imports and export quotas, etc. under TCC to increase, reduce, or remove existing protection rates of import duty, including any necessary change in the classification. The existing rates may be increased or decreased to any level on one or several stages, but in no case shall be higher than a maximum of 100% ad valorem. 2. To establish import quota or to ban imports of any commodity as may be necessary. 3. To impose an additional duty on all imports not exceeding 10% ad valorem whenever necessary. Limitation imposed regarding the flexible tariff clause. Conduct by the Tariff Commission of an investigation in public hearing. The Commissioner shall also hear the views and recommendation of any government office, agency, or instrumentality concerned. The NEDA thereafter shall submit its recommendation to the President. Number 2. The power of the President to increase or decrease the rates of import duty within the above-mentioned limits fixed in the Code shall include the modification in the form of duty. In such a case, the corresponding ad valorem or specific equivalence of the duty with respect to the imports from the principal competing country for the most recent representative period shall be used as basis. Exempted from taxation. Section 28. Charitable institution charges and parsonages or convents appertinent thereto, mosques, non-profit cemeteries, and all lands, building, and improvements actually directly and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation. Exempted. 1. Charitable institution. 2. Churches. 3. Parsonages or convents appertinent to churches. 4. Mosques. 5. Non-profit cemeteries. 6. All lands, buildings, and improvements actually, directly, and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation. Kind of tax exemption under 28. Number 3. The exemption created by Section 28 is only for taxes assessed as property taxes and not excise tax. CIR versus CA. Exclusively. The phrase exclusively used for educational purposes extends to facilities which are incidental to and reasonably necessary for the accomplishment of the main purpose. Valley College versus Aquino. PCGG has no power to grant tax exemption. Chavez versus PCGG. 4 elements to be considered in determining whether an enterprise is a charitable institution or entity. 1. Statute creating the enterprise, its corporation purposes, its constitution and bylaws, methods of administration, nature of actual work performed, character of service rendered, indefiniteness of the beneficiaries, use and occupation of the properties. Long Center versus QC. Section 28. No law granting any Section 28, number 4. No law granting any tax exemption shall be passed without the concurrence of a majority of all the members of the Congress. Reason for absolute majority. Bills ordinarily passed with support of only a simple majority or a majority of those present and voting. The above provision requires an absolute majority of the entire membership of the Congress because a tax exemption represents a withholding of the power to tax and consequent loss of revenue to the government. Power of appropriation or spending power. Section 29, number 1. No money shall be paid out of Treasury except in pursuance of an appropriation made by law. Spending power. The spending power of Congress is stated in Section 29, number 1. No money shall be paid out of the Treasury except in pursuance of an appropriation made by law. Reason. Behind the provision stands the principle that the people's treasury may be sent only with their consent. The consent is to be expressed either in the Constitution itself or in valid acts of the legislature as a direct representative of the people. By law. The provision does not say appropriation by Congress, but rather by law, a term which covers both statutes and the Constitution. Appropriation. An appropriation measure may be defined as a statute, the primary and specific purpose of which is to authorize the release of funds, public funds, from the Treasury. A law creating an office and providing funds, therefore, is not an appropriation law, since the main purpose is not to appropriate funds but to create the office. Classification of appropriation measure. General. The General Appropriation Law passed annually is intended to provide for the financial operations of the entire government during one fiscal period. Specific. Designed for a specific purpose, such as the creation of a fund for the relief of typhoon victims. CDF. A law creating CDF was upheld by the Supreme Court, saying that the Congress itself has specified the uses of the fund and that the power given to Congressman and Vice President was merely recommendatory to the President, who could approve or disapprove the recommendation. Phil Consa versus Enriquez. Truth Commission case. Facts. President Noynoy Aquino on July 30, 2010 signed Executive Order Number 1 establishing the Philippine Truth Commission of 2010 Truth Commission. The said truth is dedicated solely to investigating and finding out the truth concerning the reported case of graft and corruption during the previous administration. Issues. Issue. Does EO1 of President Noynoy Aquino transgress the power of Congress to appropriate funds for the operation of public office? Held. No. That there will be no appropriation but only an allotment or allocation of existing funds already appropriated. Accordingly, there is no usurpation on the part of the executive of the power of Congress to appropriate funds. Further, there is no need to specify the amount to be earmarked for the operation of the Commission because, in the words of the Solicitor General, whatever funds the Congress has provided for the office of the President will be the very source of the funds for the Commission. Moreover, since the amount that would be allocated to the PTC shall be subject to existing auditing rules and regulation, there is no impropriety in the funding. Judge Mendoza. Note, in this case of Birraogao versus PTC, the Supreme Court, while it recognized that the power to conduct investigations is inherent in the power to faithfully execute laws, held that Executive Order Number 1 by President Noynoy Aquino creating the Truth Commission unconstitutional for being violative of the Equal Protection Clause of the Constitution. Limitation on appropriations. Implied limitation. Appropriation must be devoted to a public purpose. The sum authorized must be determinate or at least determinable. Constitutional limitations. Specific limitations on the power of appropriation. Section 24, Section 25, number 6. Appropriation bills should originate in the House of Representatives, Article 6, Section 24. Discretionary funds appropriated for particular officials shall be disbursed only for public purposes to be supported by appropriate vouchers and subject to such guidelines as may be prescribed by law. Article 6, Section 25, Number 6. Constitutional limitations on special appropriation measures. Section 25, Number 4, Section 29, Number 2. Number 1. Must specify the public purpose for which the sum is intended. Must be supported by funds actually available as certified to be national treasurer or to be raised by a corresponding revenue proposal including therein. Article 6, Section 25, Number 4. Number 3. Prohibition against appropriation for a sectarian benefit. Article 6, Section 29, Number 2. Constitutional rules on general appropriation law. Section 25, Number 1, 2, 3, 5, and 7. Section 29, Number 2. 1. Congress may not increase the appropriations recommended by the President. 2. The form, content, and manner of preparation for the budget shall be prescribed by law. 3. Rule on riders. 4. Procedure for approving appropriations for Congress. Article 6, Section 25, Number 3. 4. Procedure for approving appropriations for Congress. Article 6, Section 25, Number 3. 5. Prohibition against transfer of appropriations. Article 6, Section 25, Number 5. Rule on automatic reappropriation. Article 6, Number 7, Section 25. Prohibition against appropriations for a sectarian benefit. Article 6, Section 29, Number 2. Non-establishment provision. Section 29, Number 2. No public money or property shall be appropriated, applied, paid, or employed directly or indirectly for the use, benefit, or support of any sect, church, denomination, sectarian institution, or system of religion, or of any priest, preacher, minister, or other religious teacher or dignitary as such, except when such priest, preacher, minister, or dignitary is assigned to the armed forces or to any penal institution or government orphanage or leprosarium. No public money or property shall be appropriated, applied, paid, or employed directly or indirectly for the use, benefit, or support of any sect, church, denomination, sectarian institution, or system of religion, or any priest, preacher, minister, or other religious teacher or dignitary as such. Public money may be paid to a priest, preacher, minister, or dignitary if he is assigned to the armed forces or to any penal institution, government orphanage, or leprosarium. General or special appropriation. Whether the appropriation be general or specific, it must conform to the prohibition against the use of public funds or property for sectarian purposes. Purpose of the provision. This provision must be read with Article 3, Section 5 of Religious Freedom and Article 2, Section 6 on the separation of churches and state. Separation of church and state. Its purpose is to further bolster this principle and emphasize the neutrality of the state in ecclesiastical matter. Special fund. Section 29, Number 3. All money collected on any tax levied for a special purpose shall be treated as a special fund and paid out for such purpose only. If the purpose for which a special fund was created has been fulfilled or abandoned, the balance, if any, shall be transferred to the general funds of the government. Tax levied for a special purpose. All money collected on any tax levied for a special purpose shall be treated as special fund. For such purpose only, all money collected on any tax levied for a special purpose shall be paid out for such purpose only. Balance to the general funds. If the purpose for which a special fund was created has been fulfilled or abandoned, the balance, if any, shall be transferred to the general funds of the government. Budget and appropriation. Section 25. The Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. The form, content, and manner of preparation of the budget shall be prescribed by law. Budget is only a proposal, a set of recommendations on the appropriations to be made for the operation of the government. It is used as a basis for the enactment of the General Appropriations Law. The budget as a restriction on appropriations. The Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. The reason for the above provision is the theory that the President knows more about the needed appropriations than the legislature, being responsible for the proper administration of the executive department. The President is ordinarily the party best qualified to know the maximum amount that the operation of his department requires. Preparation of budget. The form, content, and manner of preparations of the budget shall be prescribed by law. The rules on riders, Section 25, no provision or enactment shall be embraced in the General Appropriations Bill unless it relates specifically to some particular appropriation therein. Any such provision or enactment shall be limited to its operation to the appropriation to which it relates. 2001 bar question. Every provision or enactment in the General Appropriations Bill must relate specifically to some particular appropriation therein. Every such provision or enactment shall be limited in its operation to the appropriation to which it relates. Purpose to prevent riders or irrelevant provisions that are included in the General Appropriations Bill to ensure their approval. Procedure in approving appropriations for the Congress. Number 3. The procedure in approving appropriation for the Congress shall strictly follow the procedure for approving appropriations for other departments and agencies. Same procedure. The procedure in approving appropriations for the Congress shall strictly follow the procedure for approving appropriations for other departments and agencies. Reason to prevent the adoption of appropriations sub rosa by the Congress. A special appropriations bill. A special appropriations bill shall specify the purpose of which it is intended and shall be supported by funds actually available as certified by the National Treasurer or to be raised by a corresponding revenue proposal therein. Special appropriations bill shall 1. Specify the purpose of which it is intended, 2. Be supported by funds actually available as certified by the National Treasurer, or 3. Be supported by funds to be raised by a corresponding revenue proposal therein. No transfer of appropriations. Number 5. No law shall be passed authorizing any transfer of appropriations. However, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of Constitutional Commission may by law be authorized to augment any item in the General Appropriations Law for their respective offices from savings in other items of their respective appropriations. 1998 bar question. Prohibition of transfer. No law shall be passed authorizing any transfer of appropriation. Reason. This provision prohibits one department from transferring some of its funds to another department and thereby make it beholden to the former to the detriment of the doctrine of separation of powers. Such transfers are also unsystemic, besides in effect disregarding the will of the legislature that enacted the appropriation measure. Augmentation of items from saving. The President, the Senate President, the House Speaker, the Chief Justice, and the heads of Constitutional Commission may, by law, be authorized to augment any item in the General Appropriations Law by the respective offices from savings in other items of their respective appropriations. In this case, there is no danger to the doctrine of separation of powers because the transfer is made within a department and not from one department to another. Exclusive list. The list of those who may be authorized to transfer funds under this provision is exclusive. However, members of the Congress may determine the necessity of realignment of the savings. Phil Consa versus Enriquez. Discretionary funds. Discretionary funds appropriated for particular officials shall be disbursed only for public purposes, to be supported by appropriate vouchers and subject to such guidelines as may be presented by law. Public purpose. Discretionary funds appropriated for particular officials shall be disbursed only for public purposes, to be supported by appropriate vouchers and subject to such guidelines as may be prescribed by law. Reason. This was thought necessary in view of the many abuses committed in the past in the use of discretionary funds. In many cases, these funds were spent for personal purposes, to the prejudice and often even without the knowledge of the public. Automatic reenactment. If by the end of any fiscal year the Congress shall have failed to pass the General Appropriations Bill for the ensuing fiscal year, the General Appropriations Law for preceding fiscal year shall be deemed reenacted and shall remain in force and effect until the General Appropriations Bill is passed by the Congress. Reason. This is to address a situation where Congress fails to enact a new General Appropriation Act for the incoming fiscal year. Initiative and Referendum, Section 32. The Congress shall, as early as possible, provide for a system of initiative and referendum, and the exemption therefrom, whereby the people can directly propose and enact laws or approve or reject any act or law or part thereof passed by the Congress or local legislative body after the registration of petition therefor, signed by at least 10% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters thereof. Initiative and referendum. The Congress shall, as early as possible, provide for a system of initiative and referendum, and the exception therefrom. Petition. A petition must be signed by at least 110% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters thereof. The petition must be registered. The petition must then be registered. RA 6735. The current implementing law is RA 6735, an act providing for a system of initiative and referendum. Initiative. The power of the people to propose amendments to the Constitution or to propose and enact legislation. Three types of initiative. The initiative of the Constitution, which refers to a petition proposing amendments to the Constitution. Initiative on statutes, which refers to a petition proposing to enact a national legislation. Number 3, initiative on local legislation, which refers to a petition proposing to enact a regional, provincial, city, municipal, or barangay law, resolution, or ordinance. Local initiative, not less than 2,000 registered voters in case of autonomous regions, 1,000 in case of provinces and cities, 100 in case of municipalities, and 50 in case of barangays, may file a petition with the regional assembly of or local legislative body, respectively, proposing the adoption, enactment, repeal, or amendment of any law, ordinance, or resolution. Section 13, RA 6735. Limitations on local initiative. 1. The power of local initiative shall not be exercised more than once a year. 2. Initiative shall extend only to subjects or matters which are within the legal matters which are within the legal powers of the local legislative bodies to enact. 3. If any time before the initiative is held, the local legislative body shall adopt in toto the proposition presented, the initiative shall be cancelled. However, those against such action may, if they so desire, apply for initiative. Question. Petitioners file the petition with the COMELEC to hold a plebiscite on their petition for an initiative to amend the Constitution by adopting a unicameral parliamentary form of government and by providing for transitory provision. Answer. An initiative to change the Constitution applies only to an amendment and not revision. Revision broadly implies a change that alters basic principle in the Constitution, like altering the principle of separation of powers or the system of checks and balance. The initiative of the petitioner is a revision and not merely an amendment. Lambino versus Comelec. Referendum. The power of the electorate to approve or reject legislation through an election called for the purpose. Referendum. Power of the electorate to approve or reject legislation through an election called for the purpose. Two classes of referendum. 1. Referendum on statutes, which refers to a petition to approve or reject an act or part thereof passed by Congress. Referendum number 2 on local laws, which refer to a petition to approve or reject a law, resolution, or ordinance enacted by regional assemblies and local legislative bodies. Section 2 CRA 6735. Prohibited measures. The following cannot be subject to an initiative or referendum. Petition embracing more than one subject shall be submitted to the electorate. 2. Statutes involving emergency measures, the enactment of which is specifically vested in Congress by the Constitution, cannot be subject to referendum until 90 days after their effectivity. Section 10 RA 6735. Question. Is the people power recognized in the Constitution 1987, 2000, 2003 bar examinations? Answer. People power is recognized in the Constitution. Article 3, Section 4 of the 1987 Constitution guarantees the right of the people peaceable to assemble and petition the government for redress of grievances. Article 6, Section 32 of the 1987 Constitution requires Congress to pass a law allowing the people to directly propose or reject any act or law or part of it passed by Congress or a local legislative body. Article 13. Section 16 of the 1987 Constitution provides that the right of the people and their organizations to participate in all levels of social, political, and economic decision making shall not be abridged, and that the state shall, by law, facilitate the establishment of adequate consultation mechanism. Article 17. Section 2 of the 1987 Constitution provides that, subject to the enactment of an implementing law, the people may directly propose amendments to the Constitution through initiative.